Hi everybody, good evening and welcome to Thorough Newspaper Analysis. This is the video for the 10th of June 2024. Now let's proceed and have a look at the pointers of discussion for the day. So please note the first segment for today's discussion would be the editorial segment. And here we discuss an article that is taken from Indian Express. See, this article essentially talks about some unresolved disputes that are, plaguing the relationship between two Indian states. One is Andhra Pradesh and second is Telangana. So we'll understand what are some of the unresolved issues between these two states that went to the Supreme Court. Secondly, we talk about the news updates for the day, and this is going to be followed by the last segment of legal news. So without further ado, let's start with the article and let's first have a look at the title of it. Andhra Pradesh versus Telangana, unresolved issues between the states that went to the court. So first of all, let's understand the context. And here what we need to understand is that this is a sort of, a political sort of a statement. So for our purpose, we're going to stick to the, factual understanding of the aspects and the legal aspects of this entire issue without getting into, let's say, the politics of it. So let's have a look at the context. Political analysis of TDP's kingmaker position in the NDA. They've discussed the years of efforts that Chandrababu Naidu he has put in to obtain special category status for Andhra Pradesh, which could compensate for the loss of revenue suffered after the undivided state. It was split into two states, namely Andhra Pradesh and Telangana back in 2014. A decade on, because now we are in the year 2024, so we've seen 10 years. So during these 10 years, several issues related to the Andhra Pradesh Reorganization Act of 2014 remain pending between the two successor states, and also Telangana Chief Minister. He has said he hopes that they are resolved soon. The creation of the new states, it was followed by division and apportionment of assets of undivided Andhra Pradesh. Now, courts were required to adjudicate several disputes that arose as a result of this division. A few of the major legal disputes are discussed below, which we'll take up for discussion shortly. The states, they are embroiled in some other disputes as well, including disputes over competing claims on pending power generation dues, division of Andhra Pradesh State Financial Corporation's asset, and over the sharing of TRISHNA and Godavari waters. We've already seen that, there is a dispute between the Haryana and Delhi government over water sharing. We just saw how, there was a dispute and the matter reached the Supreme Court. So now coming back to today's topic, let's understand the 9th and 10th schedule to the Reorganization Act, Andhra Pradesh Reorganization Act of 2014. So in December 2022, Andhra Pradesh approached the Supreme Court claiming that the division of assets contained in the 9th and 10th schedules of this particular Act of 2014, they had not commenced, even though the Act clearly apportioned them between the two successor states. But this division, it has not commenced. According to the petition by the Andhra Pradesh government, the Act of 2014, it lists 245 institutions or assets, 142 in Schedule 9 and 91 in Schedule 10 and 12 unmentioned in the Act. They are owned by the erstwhile state of Andhra Pradesh, valued at nearly rupees 1,42,601 crore, and that 91% of these assets, they are located in Hyderabad. Thereby, clearly, this is benefiting the state of Telangana. As of June 2nd, 2024, which is currently, the Hyderabad, it is the capital city of Telangana alone and no longer the shared capital of both the states. So Andhra Pradesh, it is in the disadvantageous position of having to start from the scratch. This was also, one of the contentions in the petition by Andhra Pradesh government. Now, these institutions, says the petition, perform a range of basic and essential functions, including agriculture, then dairy development, education, medical services, minority and backward class development, and so on and so forth. None of these assets, they have been apportioned between the successor states, the petition further claimed. According to Andhra Pradesh, Telangana's inaction, it has led to a multitude of issues, thereby adversely affecting and violating the fundamental and other constitutional rights of the people who are residing in the state of Andhra Pradesh. AP, it has also asked the Supreme Court to direct Telangana to start handing over assets which are specified in the 9th and the 10th schedule of the 2014 Act under the supervision of neutral arbitrator or a retired judge of the Honorable Supreme Court. In December 2023, the case was listed for a final hearing in March 2024 by Justices Sanjeev Khanna and S.V.N. Bhatti. However, the case, it was not taken up and hence it remains pending. Now let's talk about another facet in this dispute, which is with respect to Andhra Pradesh State Council for Higher Education. So in 2016, please understand, the Supreme Court decided on a dispute where Telangana claimed ownership of all funds and assets of the Andhra Pradesh State Council of Higher Education. The state of Telangana argued that the 2014 Act, it does not contain any provisions for the apportionment of institutions under the 10th schedule, such as this institution. And as a result, since the assets of this particular higher education council, they were located in Hyderabad, so the state of Andhra Pradesh has no right to them. Now, the Supreme Court, however, rejected this argument and invoked Section 47 of the 2014 Act, which states that the apportionment of assets, it can be subject to adjustment, quote unquote, as may be necessary to secure just, reasonable, and equitable apportionment of assets and liabilities amongst the successor states. Thus, the Supreme Court directed the State Council of Higher Education, directed that the assets of this institution should be divided between the two states based on population ratio. So the argument by Telangana that, since its location is in Hyderabad, so Telangana is the righteous body and, the state concerned for, for securing the ownership of its funds. So that's not a legit argument, and it should rather, the asset should rather be, divided between the two states depending upon the population ratio. In 2016, now we talk about the Andhra Pradesh Dairy Development Cooperative Federation Limited. So in 2016, the same year as this, the Telangana government transferred the assets of the Dairy Development Board in Hyderabad to the Telangana State Dairy Development Cooperative Federation from the Andhra Pradesh Dairy Development Cooperative Federation Limited. Now, the Federation for Andhra Pradesh, it challenged this government order at the Telangana High Court with the argument that as a 9th schedule institution, its asset had to be fairly apportioned in the manner which is provided in the 2014 Act. So in the lines of this, just like Supreme Court did with the higher education institution, it made reference to a section of 47 section of the 2014 Act. Similarly, they're also arguing that the apportionment should be in the manner which is specified in the 2014 Act, which is the Reorganization Act. The State Dairy Development Cooperative Federation for Telangana, however, claimed that its corresponding entity in Andhra Pradesh, which is the AP Dairy Development Corporation Cooperative Federation headquarters, they were located in Telangana and its assets belong to the state in which it is located. In 2021, the High Court held that AP's assets should be divided between it and the Telangana Dairy Development Cooperative Federation in the ratio of, so this was the ratio, which is 58.31 is to 41.68. So this would be the percentage. So the ratio would be nearly 58 is to 41. After a complete valuation of the assets by the Controller and Auditor General of India, which is CAG. Now here I have a question, and I would absolutely appreciate if you could, answer the question in the comment section. So which are the relevant provisions in the Indian Constitution with respect to, our CAG? Let's say, the appointment, the salary, who is the competent authority to determine the salary amount, and, who is the competent authority to appoint the CAG, or let's talk about its tenure or the removal of CAG. So please answer the question in the comment section. Now, both the states, they have filed petitions challenging this judgment at the Supreme Court. The matter, it was last heard by Justice Sanjay Karol, and this happened in October last year. The APMDC and the newly established TSMDC, they arrived at a plan, which is the APMDC. It is essentially is the Andhra Pradesh Mineral Development Corporation. So now, thirdly, we talk about this entity. So the Mineral Development Corporation and the newly established corresponding Mineral Development Corporation for the state of Telangana, they arrived at a plan to divide the assets of this institution of the undivided state, which is another ninth schedule institution. In March of 2018, it was based on the population ratio of 58:41. The Andhra Pradesh government approved this plan in 2019, but the Telangana government took no action on the proposal. And as a result, next year, the Andhra Pradesh government had approached the Telangana High Court with the argument that Telangana government's inaction in implementing this proposal, it was arbitrary, it was illegal. The court called the Telangana government's conduct baffling and also inexplicable, which is that it is, beyond an explanation, and ordered it to begin distributing the assets in terms of the proposal agreed to in 2018. But the Mineral Development Corporation for Telangana and the state of Telangana, it challenged this decision before the Supreme Court in 2021, and the matter, it was last heard by the three-judge bench led by Chief Justice of India D.Y. Chandrachud in February of 2024. And with this, now we proceed to the national news category, and this is the first update, which is in the category of defense for the day. So the French space agency, which is the CNES, it is teaming up with our space agency, which is ISRO, to make a high-tech infrared observation system. They're also working with Airbus to build a special instrument for the TRISHNA satellite. TRISHNA essentially stands for the Thermal Infrared Imaging Satellite for Higher Resolution Natural Resource Assessment. It will be the latest satellite which is dedicated to climate monitoring and to operational applications. It is a new mission that's a big upgrade from the existing missions that we currently have. It will take clearer pictures of Earth every 3 days, which with way better resolution. Please understand, in 2018, India and France, they agreed to work together on space, related matters, and they have a mission with NASA, which is called NISAR, and the purpose is to study Earth. Also, ISRO and JAXA, they're thinking about sending satellites to check out the moon's poles. NSA Ajit Doval, his term, it has come to an end. Let's understand who he is. Let's talk about him in a bit detail. So he's the fifth and the current National Security Advisor, NSA Advisor to the Prime Minister. He is a retired IPS officer of the Kerala cadre and former Indian intelligence and law enforcement officer. India's September 2016 surgical strike and the 2019 February Balakot airstrikes, they, across the borders with Pakistan, they were conducted under the supervision of his. Now, he's also helped us end the Doklam standoff and, took decisive measures to tackle insurgency in the Northeast. He spent a major part of his career as an active field intelligence officer with Intelligence Bureau, which is the IB. RBI keeps repo rate unchanged at 6.5%. So the Reserve Bank of India governor, RBI governor, he announced that they are not changing the policy repo rate, which is currently keeping at, being kept at 6.5%. This is because inflation is still higher than they want it to be, which is 4%. They made this decision because things are uncertain in the economy, both in India and across the world. The RBI governor further said If the economy grows by 7.2% in the current financial year, it will be the fourth year of good growth. Inflation is decreasing partly because of the central bank's action. Sometimes food prices going up slowed this down, but overall inflation, it is going down. Media baron Ramoji Rao, he passes away. The media giant Baron Ramoji Rao, he passed away while undergoing treatment at a hospital in Hyderabad. He led the Ramoji group, owned Ramoji Film City, which is the biggest film studio globally. His media empire, it included the Inadu Air newspaper, the ETV network, TV channels, and Usha Kiran movie, his production company. Haryana police secures first position in blocking mobile numbers involved in cyber crimes. So Haryana police, they are leading in blocking cell phone numbers which are linked to cyber fraud nationwide in first 4 months of this year. So data from the National Cyber Crime Reporting Portal, it shows that over 1.1 lakh numbers, they were blocked in the state within 24 hours of complaints received on 1930, the National Cyber Crime Helpline. So this is 1930. This is the National Cyber Crime Helpline. And within 24 hours of receipt of these complaints, these grievances, numbers were blocked. So this is a huge achievement, and also, a sense of respite and relief that it gives us, because we know how prevalent cyber crimes have become these days. Haryana's police chief, he mentioned that they are using a software tool which is called Astra for this purpose. This tool, it helps identify fake ID proofs which are used to get multiple cell phone numbers. And with the help of artificial intelligence, police can figure out if the same fake document, it was used to get multiple SIM cards issued. Now, with this, we proceed to the international category for the day. And the first update is with respect to environment protection and climate change. Bonn Climate Conference 2024, stage set for new climate finance goal Enroute to Baku, which is in Azerbaijan. So the Bonn Climate Change Conference, it started on 3rd of June with a focus on climate finance. It's crucial because decisions made here, they will impact the new climate finance goal at the COP29 in Azerbaijan. Progress at this halfway point, it is key to achieving ambitious outcomes. All eyes are now on the discussions and developments that are going to unfold and have unfolded. So at the opening plenary, discord arose between developed and developing countries over the new climate finance goals. For instance, Uganda speaking for the G77 and China urged for an ambitious goal which is based on needs in trillions of dollars with funds flowing from developed to developing nations. The European Union emphasized the need for diverse funding sources, stating that public funds alone, they won't be enough. Pieter Elbers, he chairs the International Air Transport Association Board of Governors. Pieter Elbers, the CEO of Indigo, is now the chair of the IATA, which is the International Air Transport Association Board of Governors. He started his one-year term after the 80th IATA annual general meeting in Dubai. Previously, he was the president and the CEO of KLM. He is the 82nd person to hold this position in this particular body, Board of Governors. Let's talk about the entity itself, which is IATA. It is a group of airlines nationwide, which is including about 330 airlines, which covers more than 80% of all air travels. Mount Kanlaon, it erupts in central Philippines. People near Kanlaon, a volcano which is in the Philippines, they are to evacuate because it erupted, sending a 5-kilometer ash cloud into the sky. The Philippines Institution of Volcanology and Seismology, it said that this volcano, it erupted in 6 minutes, for about 6 minutes, causing a strong earthquake, as the agency warned that ash fall and sulfuric odor, it would affect surrounding villages, and as a result, owing to this, evacuation process started. Now, this has brought us to the legal segment for the day, and first update is from the Honorable Supreme Court. Incarceration due to delay in trial, it violates Article 21 of the Indian Constitution. Bail can be considered in such cases despite bar under the NDPS Act. So the Supreme Court made these observations in the case of Ankur Chaudhary versus the state of MP. Let's talk about this verdict. So the division bench noted that when a trial takes too long, then it violates the important right which is guaranteed by the Indian Constitution under Article 21, and which we know it provides protection against life, right to life and personal liberty. So therefore, in such cases, conditional freedom, it might be granted despite legal restrictions which are outlined under the special statute, which is the NDPS Act, and to be precise, Section 37, subsection 1, clause B of this Act. Section 37, it states that bail shouldn't be granted unless the accused can prove that they're likely innocent and won't commit another offense if released. So in this case, the accused was held for over 2 years for drug-related charges, and the trial hadn't finished yet. So as a result, therefore, the Supreme Court observed that if there is an undue delay in the completion of the trial, then there would be no impediment, there would be no restriction, no bar hurdle to consider the grant of bail to the accused under the NDPS Act, despite not meeting the stringent test which is set out in Section 37 of this Act. Next up is an update from the Honorable High Court of Bombay, and this is in the case of Rajiv Bansal and others versus the state of Maharashtra and others. Let's talk about it. So the Supreme Court has held that withholding of salary or emoluments, it does not fall within the ambit of offense of cheating. A single judge bench of the Bombay High Court, in the case of Rajiv Bansal, it held that when there is a withholding of salary or emoluments, then it does not fall under the ambit of the offense of cheating. The court held that for the offense of cheating, there needs to be deceit which is coupled with injury. Cheating involves deception, there is fraudulent and dishonest inducement, and thereby making the person deliver any property or to consent that any person shall retain any property. And to constitute the offense of cheating, the intention of the accused should be dishonest from the inception or from the start of the transaction. So that was the High Court's observation, and this has brought us to an end of our Q&A. Thank you so much for watching. Have a wonderful day ahead.